I would like to thank everybody for joining us here, and thank you, Scott. My name is Garrett Sutton. I'm an attorney in Reno, Nevada. I work with Robert Kiyosaki and the Rich Dad Advisor Group. And, you know, when Linda asked me to come down to Santa Clara in April, I was really looking forward to it because my daughter is a senior at the University of Santa Clara. And she was really looking forward to her spring semester of her senior year. And I have fond memories of those days, too much fun in the sun. And, you know, 50 years from now, they're going to ask her, Grandma, what was your spring senior semester like? And she's going to have to say, well, I sat on the couch, took online classes, and watched Netflix. But, you know, that's everybody's experience. We're all in this together. We're all going to get through it. It's all going to be fine. And so what I'd like to do is talk about some asset protection topics and some new developments within the law that have been kind of foreshadowed by all the coronavirus issues we have right now. So I'd like to advance the first slide, and I'm going to learn how to do that. There we go. All right. So right now, they say we're experiencing a black swan event, which is true. And it's kind of interesting, the history of the black swan. In Europe in the 13th, 14th, 15th century, they would describe events as black swan events because a black swan was so rare. It was, you know, there were plenty of white swans. And the black swan would happen every now and then, kind of like a reverse albino. You would have a black swan, so it was very rare. And so then the British needed a penal colony after, you know, we won the revolution at Yorktown, and they couldn't bring their prisoners from England over to the Washington, D.C. area. That's where they used to drop all the criminals. So they had to discover a new place, a new penal colony, and they discovered it in Australia. And it only took them 7 years from Yorktown to the settling of this penal colony. 1788, they settle in Australia. And what do they find in Australia but black swans? There are plenty of black swans. And so I think this is important historically because we talk about a black swan event as something that happens in a rare occurrence. But if you look at the history of these viruses, I mean, these black swan events are happening with regularity. I mean, you had SARS 2002 to 2004, the swine flu 2009, MERS 2012, Ebola 2014. So I think it's important for people to realize that these black swan events are happening more often, and we need to prepare for them. So we're going to talk about some of the ways that you can contractually prepare for them. So we'll move on to the next slide here. Let's see if that works. Good. Okay, great. Thank you, Melissa. So the term up there is force majeure. And this is, in legal circles, everybody's talking about force majeure. And it started out as, it means superior force. And it started out, it applied to Napoleon's army. I mean, those guys were a force majeure, at least until they got to Russia. But Napoleon's army was pretty badass. And so the term force majeure, I don't know if people have read my book, Loopholes of Real Estate, but in this book, we talk about how defensive terms and military terms enter the contractual language. And force majeure has entered our contractual language. And in terms of superior force, it would be a fire, a flood, some sort of event that's not contemplated, but we need to have a contractual provision saying that if there is a fire and we can't perform on the contract, the force majeure says we're going to settle it with insurance, we're going to excuse the performance because of the force majeure provision. Well, it's kind of interesting that after SARS in 2006, all the insurance companies, they have form documents that they all agree on, and all the insurance companies excluded viral outbreaks from their insurance contracts. And so if there is a force majeure provision in your contract of insurance, there's a very good chance that the viral excuse of performance is excluded. In other words, the insurance company doesn't have to cover you if there's a viral outbreak. Now, the attorneys, pardon my profession, the attorneys are already planning on how to get around this contract or this term in insurance contracts. And basically, they're going to say that your insurance agent didn't advise you that there was a force majeure provision for viral outbreaks in the contract. Now, I'm kind of one who believes that if you have a contract, you should read it, or at least have your attorney read it for you. But this is going to be the argument that is going to be made for insurance coverage. Now, you can also imagine that attorneys and various business owners are going to complain that there's no business interruption insurance during these times. And, you know, it may work. We don't know, but sometimes the states will say to insurance companies, look, you got to help out on this outbreak. If you want to do business in our state, we need you to kick in some money. So it'll be interesting to see what happens. But another thing, Scott, that people should know is a lot of times you don't have a force majeure provision in a contract, all right? So if it's not in the contract, we have what's called, frustration of purpose. And the most interesting case in the field is called the tornado case, which is a perfect name for this case. It was an 1883 U.S. Supreme Court case. And what happened was the tornado was a ship that burned down. It burned to the ground. It was unseaworthy. It couldn't deliver the freight that it had promised to deliver. There was nothing in the contract about a contract clause dealing with fire. So if the parties contemplate an action that can't be performed, and there's nothing in the contract about it, the Supreme Court said, okay, you're excused from performance. And this is going to be a big issue coming up because a lot of these contracts don't have force majeure provisions. So I'm just going to read this, Scott, and hopefully people will take this away. This is all important because with rent, with all your dealings with vendors and everything, you know, frustration of purpose is going to be a defense to that contract. So here we talk about the torpedo case. American courts still apply this principle, although with some modifications. In essence, a party asserting the defense of impossibility of performance, impracticability of performance, and or frustration of contractual purpose must establish the following, right? So you're in court or your attorney's writing the letter, and here's what you have to establish. 1, the unexpected occurrence of an intervening act. 2, such occurrence was of a character that its non-occurrence was a basic assumption of the agreement. That's important. When you entered into the agreement, you and the other party had no idea that there was going to be a coronavirus outbreak, right? The non-occurrence of an outbreak was a basic assumption, and the occurrence of the coronavirus made performance impracticable. So if the contract does not include a force majeure clause, right, the courts will apply common law principles adopted by the U.S. Supreme Court, and they will allow the frustration of a contract's purpose to the extent the parties are excused from performance. So this is very fact specific, but for all your listeners, Scott, if you don't have a force majeure provision saying superior force, corona outbreak, I don't have to perform the contract, you then fall down to the torpedo case from the U.S. Supreme Court saying that the contract cannot possibly be performed. We didn't contemplate this, and there's no way for it to be properly performed. So that's a little heads up on what you're going to see in the coming weeks and months here. Now, rent abatement. All right. One of tenants' arguments is going to be, look, there was an interruption of essential services, right? I couldn't use the property as I thought I was able to. And one of the issues is going to be, is the stoppage within or outside the landlord's control. And here, you know, coronavirus, that's outside the landlord's control. So does the tenant get a forgiveness of some rent? And, you know, there's no one fixed answer here, but I'll tell you my experience. So I have a strip center. I won't say what city, and there are two tenants. One is a local business. The other is a national tenant. The local business, people around town really like this business. It's a popular spot. He does good things in the community. And I could see what was coming. And I called the property manager and said, look, this local guy is going to get killed. So let's just give him free rent for 2 months. And he was very appreciative. And I think that if you have the ability to give people, you know, a little discount in these times, that is a good thing. And you know, people will remember that. All right. So the national tenant, I didn't say anything to them. They're a national tenant. And I won't reveal who the tenant is, but then I get a letter from them. And they are talking about the outbreak and the restrictions. And here's the language that they sent me. These restrictions have resulted in a materially reduced ability to access our premises and/or operate our business. Accordingly, while expressly invoking and reserving all other rights, remedies, and defenses under the lease at law and by equity, attorneys have to say that, we are hereby providing landlord with notice that, consistent with the industry, good to put in, and until such time as we are able to resume normal operations, we will be paying 50% reduced rent due to the impact of the continuing events of COVID-19. We take this interim relief in good faith and in the hopes of being able to at least sustain this reduced level of operations as opposed to having our store closed. Notwithstanding the foregoing, we further reserve the right to close the store and abate all rent if and as such circumstances change. Now, interesting. There's really nothing in the lease that allows them to do this. But this is, these are unique times. I mean, this is like a time of war. And for them to send that letter, I don't begrudge them, right? They have to do what they have to do. And, you know, I wish they had called me. I could have talked through it with them. But this is the kind of thing that is happening all over the country. And I think as landlords, you've got to be a little bit flexible. You've got to understand that these are very unique times. And for me, with the local tenant, I was just happy to help him out. And if, you know, if you can help people out, all the better. All right. So let's talk about new laws that have come into effect. Now, a lot of this has been overshadowed by the coronavirus issue. So, you know, a lot of people aren't aware of this, but in Oakland, landlords now cannot conduct criminal background checks. So that if you're going to take a new tenant and, you know, prudence requires you do a background check, that is now prohibited. And, you know, I understand both sides of this, right? Maybe we're sending too many people to jail. Maybe criminals can't, you know, they're homeless because they can't get into a property. But here's the thing. If you do a background check and it comes out, the penalties are pretty severe. I mean, the tenant can get punitive damages, attorney's fees. There are even criminal penalties for this. So you've got to be really careful if you're renting in Oakland. I think you certainly want title in the name of an LLC, right, to limit your personal liability. We'll be talking about that in a minute here. We are going to talk about asset protection, but these new laws are important to know because in Oakland, the cities around the Bay Area are looking at Oakland to determine if they should have such a similar law. But if you make the mistake, there's significant penalties. If you may want to have a management company do this so that if they make the mistake, it's their problem, not your problem. All right, but here's kind of the catch-22. You know, landlords around the country are still responsible for criminal activity on the property. So here's the catch-22. In Oakland, you can't check on their criminal background, but you can still be held responsible for criminal activity on your property. This is not a good thing. I mean, if your investment guidelines are to avoid difficult catch-22 situations, I don't think you want to invest in Oakland until maybe the courts say landlords in Oakland are not responsible for criminal activities on the property. But then where does that go? So interesting, a new law to know. All right, another new law to know, and I'm sorry that the screen is covered up by our mugs here, but I'll read it. Okay, in San Francisco, they just passed a bill, and they want affordable housing. And so you have to build 2,042 units of affordable housing in order to get the annually approved 875,000 square feet of office space approved. Now, if you only build half of those units, you only get half of the office space. And so, you know, if you don't want more housing, I mean, more office space in San Francisco, this is a good way to go. But if you want affordable housing in San Francisco, tying it to office space construction, you know, may not be the best way to go. Now, if you're building office buildings, not in San Francisco, but in other Bay Area communities, this is a great opportunity. The voters of San Francisco just made your project all that more profitable. All right, but here's what's interesting is, and I'm sorry that screen's cut off. It said by tying future office development to an affordable housing goal that the city has never met, the measure is likely to lead to high office rents, reduced tax revenue, reduced incomes, and reduced unemployment across the city's economy.
We're seeing your full screen, Garrett, by the way. So we're not
good. Okay, so thank you for that, Scott. This was San Francisco's chief economist said this, right? You know, this is going to affect the city. And, you know, when voters get in the way of real estate development, sometimes, you know, bad things happen. So it's just important for you to know these new rules. And then here's another one. We have California statewide rent control. So properties over 15 years old, it's a 5% plus inflation or 10%, whichever is less. And you say, okay, well, you know, the properties are over 15 years old. This means that people will continue to build new properties. But here's the issue. You can't raise rents for capital improvements on older buildings. So, you know, that means that there's going to be deferred maintenance in California. Older buildings, you can't raise the rent to improve them, and they're just going to be a lot of deferred maintenance in the Golden State. So that's something for all of you to realize. Statewide rent control. And their new rules, this came in, and these rules are in effect January 1st, 2020 in the state of California. Their new rules for evicting tenants. And it's somewhat complicated. If you have rentals in California, be sure and talk to your local attorney on the new rules for evicting tenants. All right, so let's get to the asset protection. I know that's why a lot of you tuned in, and here's how we like to talk about asset protection. And in these days, certainly we need to consider how are we going to protect our assets. So in this case, we have John's duplex. And if you go to the county recorder and you look up 123 Elm Street where the duplex is located, it says the title is in the name of John Smith. It's held in John's name personally, all right? So if a tenant sues, that's called the inside attack. The tenant is leasing the property from John. And if something bad happens on the property, hopefully John has insurance, but if it exceeds the insurance, then the tenant has a claim against John personally. All right, so not only can they get the equity inside this duplex, they can get all of John's other personal assets. And I know people will say at the start, well, you can't really afford an LLC, and in California it's $800 a year, and just wait until you can afford to set up the LLC. And what happens is people will take title in their individual name, and they'll forget to transfer title into an LLC. And all of a sudden, there's something bad happens on the property, and all of your assets are exposed. Your personal bank account, the equity in your house, all of your assets are exposed to that claim. This is not good. The other way we have an issue is when you get in a car wreck. It has nothing to do with the real estate, but it is this property here, John's duplex, is something that could satisfy a claim from a car wreck victim. All right, John owns title in his name. John was in the car wreck. The car wreck victim has a claim against John. Have at the duplex because it's in John's name individually. All right, let's look at a better way to do this. Now we have the duplex title at the county is in the name of an LLC. So on the inside attack, the tenant can get what's inside the LLC. He's renting from the LLC. That's who he does business with. And he can get the equity inside that LLC. And some people will say, well, geez, that's not asset protection. He can get the equity. Here's what's important. The tenant can't get anything outside of the LLC. He's limited to what's inside the LLC. He can't get at John's personal bank account. He can't get at John's equity in his house. So that raises the question, how many properties do we put in one LLC? And it's a judgment call on the client's part. If you want one or two, that's fine. I wouldn't put 10 properties in one LLC because a tenant suing on one property could get the equity in the other 9. So then let's look at the outside attack. Remember the car wreck. Now, in California, if you have property inside an LLC and you get in the car wreck, the courts in California say, have at it, Mr. Car Wreck victim. Force a sale of the duplex to satisfy the claim. And you got to look at this from two sides. I understand why the courts would say, well, the victim was injured, and you own the LLC, have at it. We like to protect better than that, though. And so we like using a Wyoming or Nevada LLC, which we'll discuss in the next slide. But for right now, just know that with a Wyoming or Nevada LLC, instead of California saying, have at the LLC, force a sale of the duplex. In California, Nevada, Delaware, other good states, what they say is you can get what's distributed from the LLC. We're not going to let you barge in and force a sale of the asset. We're going to allow what's called a charging order, meaning when John distributes money to himself from the LLC to John, you can get that money. And, it's not a great thing for attorneys who are on contingency fees to wait around to get paid, to monitor whether payments have been made. Attorneys are on contingency, meaning they get a percentage of what they collect in the case. And, 30 to 40%, is it worth their time to monitor a charging order? Their time is much better spent going on against the next party who has insurance. So the charging order is a good deterrent for litigation. So let's see how we put it all together. We would have the duplex in California in a California LLC, And let's say you have a triplex in Oregon. We would put that property into an Oregon LLC. And then we would have those two LLCs on title owned by one Wyoming LLC. And this is where the outside attack comes in. On the inside attack, it's the same in all 50 states. The tenant can get what's inside the duplex if they sue. In the triplex, if the tenant is injured in Oregon, they can sue in an Oregon court against the LLC. That's true in all 50 states. The key is on the outside attack, where you get in the car wreck or some other claim is brought against you. The charging order says that John is going to make distributions from the California and the Oregon LLC to the Wyoming LLC. When the Wyoming LLC makes distributions to John, the car wreck victim can receive those distributions. So it's a lien on distributions. But what if the money is distributed from the California LLC and the Oregon LLC to the Wyoming and no further money is distributed? Well, that's good. What if you leave the money in the California and Oregon LLC? That's good. There are ways to frustrate this. We're going to do it legally, but setting this up is something that attorneys on contingency fees don't like to see. Going to Wyoming, monitoring charging orders is really a pain. Now, I always recommend that my clients have an umbrella policy of insurance so that with your personal auto and your personal home, you have an extra, let's say, $1 million of coverage. And an umbrella policy is only $400 for an extra $1 million in coverage. That's your biggest risk, is that horrific car wreck. You have enough umbrella insurance. The attorneys can get at the umbrella insurance. They're really good at that. They're not very good at getting at these Wyoming LLCs. So that's how we like to structure things. Now, it's way beyond the length of this class to talk about California and what they do. But the California, you're going to have to qualify the Wyoming LLC into California if you live in California. And it's part of the House of Mirrors that California has created. But when you get on a consult with us, we can explain all that. But this is the structure we like. A title property, a title holding LLC in the state where the property is located. And then those two or more are owned by one Wyoming LLC with the charging order protection. All right, let's go on. The asset protection, this is not expensive, and don't listen to these people, especially the non-attorneys who say that this costs thousands and thousands of dollars. It doesn't. Wyoming, $52 a year. They don't list your name on the state website, which is great. Nevada is $350 a year. Your name is listed on the state website. There are reasons for Nevada LLCs and corporations. Nevada is the only state that has charging order protection for corporations. But when we give people the choice, Wyoming, $52 a year, and privacy, that's the choice they usually take. Both states are great. They both protect single member LLCs, meaning one owner LLCs. So the charging order was originally designed to protect the innocent partner so that, your partner gets into trouble and they're not going to force a sale of the LLC or LP because we've got an innocent partner. Well, that argument goes away with a single member LLC. There's only one person. But Nevada and Wyoming and Delaware, it's great. They compete to be the best states for asset protection. So we have this competition. Nevada and Wyoming will protect single member LLCs, which is great for us. So final thoughts here. I want to keep on the schedule for you, Scott. Asset protection. So set up the LLCs now. When you take title to that property, just get it in the name of an LLC. If you try and do it later, if you get sued by a tenant and you try and put it into an LLC at that point, that's called a fraudulent conveyance. And anytime the word fraud is in a phrase, it's not good. So we don't want to do a fraudulent conveyance. You got to set this stuff up now. As Robert Kiyosaki says, it's too late to put on the seatbelt after the accident. So you just really need to take these steps now. Now, if you've already got your LLC formed and you've got some time on your hands, you know, don't spend all day looking at Netflix. Now is a good time to look at your documents. Let's make sure your LLC and corporate documents are in shape. You have an operating agreement, you have minutes, you've done the right things. And if you haven't, we can help you clean them up. We clean up LLC and corporate documents all the time. Don't tell anyone, but we'll help you clean it up. Another thing to look at are the succession plans, right? When you have a single member LLC and you're the only owner, what happens when you pass? Do you have a living trust? We have a special operating agreement for one single member LLCs because there is that issue of who's going to run the LLC when the person passes. And corporate formalities. This is really important as well. We need to make sure that our formalities are in place. And we set up the LLC and we can see it. We're creating this wall called the veil. The corporate veil applies to LLCs. We need to do the annual filings every year. We need to pay the fees to the state. We need to do the minutes. I don't care what they say, LLCs don't need minutes. They do when you walk into a courtroom. So we need to do the LLC minutes. We need to do the tax returns. We need to make sure that we're doing all the things properly to be protected. Now, if we don't have the formalities in place, they can go right through the veil and get at you personally. And so this happens more than people would imagine. You think you set up the LLC and the corporation, it's going to protect you, but you don't follow the corporate formalities. And in 50% of all cases, the veil is pierced. So people aren't following the corporate formalities, and the person who sued the corporation and LLC is able to get through that veil because you haven't followed the formalities and get at you personally. So we don't want to do this. We want to follow the continuing obligations we have to have protection by doing the minutes, by paying the fees, by doing things properly. So that's really important. Don't forget to do those. And in wrapping up, Scott, we offer a free 15-minute consultation with an incorporating specialist. If you want to see if Corporate Direct can help you, just call this number, 800-600-1760. We'll put you on the line with one of the incorporating specialists, explain our costs. You know, it's $695 plus the state filing fees, a discount if you do 3 or more. This is not expensive, and don't let some of these non-attorneys bill you for tens of thousands of dollars when you don't need it. You need basic asset protection. You don't need offshore trusts in most cases. All right. And be very cautious of those people are going to send you down to the British Virgin Islands. You don't need to go there. Your title to your real estate is here in the US, right? A British Virgin Islands trust really doesn't help when you get sued by a tenant. All right, so a free 15-minute consultation, 800-600-1760. And Scott, I'll open it up to whatever else is next.
Okay, got a couple questions. Garrett, Maria asked, if I reside in California and create a California LLC and one in Wyoming, do I need to register in Wyoming?
Yes. So we have a California LLC on title to property, and we want that Wyoming protection. The state of California says, Maria, you live in California. You're managing the Wyoming LLC in California. Ergo, the Wyoming LLC is doing business in the state of California. Pay us the $800. Now, that sounds awful, and it is, but here's how it can save you money. Let's say you had a California property, a Utah property, and Ohio property. If we didn't have Wyoming owning those three, California would say pay $800 for the California, $800 for the Utah, and $800 for the Ohio. So by using the Wyoming holding entity, we're saving at least $800 there. So, but yes, California has its own planning requirements, and we're free to talk. We're happy to talk to you about that on the phone.
Cool. Mike asked a kind of a long question. How would you recommend handling tenants that continue to pay reduced rent over a longer period of time frame, more than the 1 or 2 month period, because of longer impact by COVID-19?
I would talk to your local attorney about that. I mean, these cases are so fact specific,
Right.
and and each jurisdiction is a little different. So I think you need local counsel for that question.
Yeah, that's a good thing. I mean, I'm in the mortgage business, and so with our borrowers, we've done the same thing. Like I said, we've reached out, hey, if you've been laid off, talk to us or affected. And we're actually calling employers too, saying making sure that their stories match up for the most part. But we offer incentives. Hey, if you pay a month, we'll give you an extra month of payments of credit towards your mortgage, and trying to keep that stuff going. So
Well, and I said before, we got to all help each other out here, right? I mean, there's got to be a little give here.
yeah, exactly. All right. So question here. Does insurance cover any rent loss due to the COVID-19? And if someone's running an active rehab business, should we use separate corporate entities besides the buy and hold properties?
Well, on the insurance issue, you'd have to look at your contract. And like I said, with after the SARS issue in '06, all the insurance companies excluded that from the contract. So you'd have to look at the specific contract. In terms of rehab, that's a good question. If you do a rehab and then sell it, and someone comes back at you, they're going to sue the LLC that did the rehab. If that LLC has 6 other properties in it, that's a target. That's an attractive target. So some of my clients will use one LLC, sell it, put it on the sidelines for a while and see if, there's going to be a mold issue or a suit. Use a second LLC for the next one. That's a strategy that is worth considering. Not putting too many properties into one rehab LLC.
Yeah, exactly. Rami asked a question. If I've got a property in California, can I create a land trust for it and the beneficiary be a Wyoming LLC?
No. The land trust, I don't like the land trust. We don't set them up, and there's all sorts of misinformation on the internet about the land trust. They don't offer asset protection. But in the situation you described, I'd rather just have a California LLC on title and then owned by the Wyoming. But with the land trust, there's no asset protection. So the beneficiary is responsible for the claim. And the beneficiary is a Wyoming LLC that's doing business in the state of California. You're going to have to qualify that Wyoming LLC to do business in the state of California. And again, I keep harping on this, but there are all these operators who tell you stuff that they want you to believe. But the truth is, California, as we all know, is very aggressive at collecting their fees. Let's face it, they're broke. All right. And so they find out that you're using a Wyoming LLC in that situation without qualifying in the state of California. Guess what the penalty is, Scott, for not paying the $800? What's the penalty?
I don't know. What's the penalty?
$12,000.
Woo!
Yeah. So, do you want to pay $800 and be, and sleep at night, or do you want to take the risk and maybe owe the state of California $12,000? I just, sometimes these cost-cutting things really aren't a wise idea.
No, and that's the same thing too. Is like I'm in Texas. If I have a property that's in California, I got to pay the filing fees regardless too, even if it's the LLC is not there.
Correct.
So, all right. So question here: what purchase contract do you recommend using for people that are wholesaling? Would you recommend the state-specific sales contract or a separate wholesaling contract?
I would talk to your local attorney about that. I mean, we're a nation, and the forms are different in every state. So I would certainly talk to your local attorney on that one.
Mm-hmm. So, May, you're asking a question for deferrals on your HELOC monthly payments. My bank denied a request. I would still talk to your local counsel on that, May, there. I mean, you guys are asking really specific questions to your case in states. You got to talk with your local counsel on that.
Well, and I always recommend, Scott, if you're getting into this, real estate business, I mean, we can help you with the formations in all 50 states, and we can structure you, but you're also going to need a local real estate attorney on your team. And I want you to have that guy before there's a problem. When there's a problem, you don't want to be rushing around looking for an attorney. Find a real estate attorney, even if you don't need him right now, to be on your team, so you have someone to call when you need them.
Christina, I'm not sure I understand. Can you put properties now in an LLC and will it be released in today's market value? I'm not quite understanding that question, Christina.
Well, let me just try and if you
Okay.
put a property that you paid $100,000 for in an LLC, the basis within the LLC is the 100,000. All right. So it's the same basis. And then when you pull the property out, you haven't sold it, you're going to pull it out and put it back in your name. Sometimes you have to do that for refinancing. The basis is still the 100,000. It's not a taxable event.
Yeah. How complicated is the tax filing? Not difficult at all. I mean, you hire an accountant to do that at your bookkeeper.
Yeah, I don't do that. I mean, we need a team here.
Yeah, well, and that's the thing. I think a lot of people are asking because they're like, oh, hey, but you need a good accountant, you need a good bookkeeper, you need an attorney in every state you're doing business with to understand what's going on in a specific state. You need an asset protection attorney too to kind of work with everybody in there, different insurance and things like that too. Michael asked the question: How does California qualify the Wyoming LLC?
So what you do is, and we do this for you, but we form the Wyoming LLC. And then we submit the paperwork to the state of California, and we pay the fees as if you'd started in California to begin with. Yep. And they always accept it. So you only have one entity. You have the Wyoming LLC that is allowed to do business in the state of California because you paid the $800. So it's just one entity. It's just allowed to do business in 2 states.
Yep. All right. Sweet. We got a question here. 1,600 for both. So 800 per entity. Or just one?
Well, I mean, in the example with, Ohio and Utah, you would just pay the Ohio and Utah fees. You wouldn't pay the California fee, but you'd have the Ohio and Utah LLC owned by the Wyoming, and you would pay the 800 there if you're a California resident. If you're not a California resident, you don't have to worry about any of this. No other state is as aggressive as California. So
amen to that.
If you're living in Texas, Scott, you can set up a Wyoming LLC, $52 a year, and the state of Texas is not going to bother you.
Nope. Exactly. That's why we love it here.
Yeah.
All right. Does the force majeure favor the tenant or the owner, the borrower or the lender?
It depends how it's written. The force majeure is designed to deal with a contract where the frustration of the contract has been eliminated. I mean, there's no reason for going ahead with the contract. So it really depends on the situation. I will say that some of the force majeure provisions are written by the business owner and the landlord. So in that case, it would favor them.
Yeah. But guys, if you're going to set up a Wyoming LLC or a California LLC, what you do is you go to the Secretary of State, you download the paperwork, you make sure that the entity name is available, you fill that out, you send it in. It's not a really difficult way to make entities out
now,
there.
I have to interrupt you, Scott, because they should call us and we'll do that.
I'm sorry. My apology. You're exactly right about that, Garrett. Go to one spot.
Because I just will say that we've seen so many horror stories where people have filled it out themselves, and then 5 years later they realize that they set up the wrong entity.
Right. Well, they never got the books. They never gone through and filed stock to themselves. They never shared ownership. They never did any of that stuff too, which is most people's like, oh, you don't need that. No, you need that, especially if you ever end up in court.
Yep.
All right. Just to make sure I understand this, if you transfer name to an LLC, basis does not go up. No, it does not go up. All right.
And again, you're going to have a CPA working with you on it. But when you transfer title from your name to your LLC, right? That is not a sale. You're just transferring how title is held.
Yep.
Right? So it's really from Scott to Scott's LLC. Scott is still the owner in each case, so there's no taxable event. The basis stays at its original basis.
Exactly. Garrett, thank you so much for coming out and spending Sunday with us, bud. I appreciate it. Great presentation. Great questions from everybody out there. Once again, everybody, take him up on the opportunity. 800-600-1760. Make a phone call on Monday. Let him have the rest of Sunday. And talk to us.
At least there were some sports on.
Yeah.
So anyway.
Rami says most lenders don't accept transfers to LLCs.
Nonsense.
It totally is nonsense. They do. It depends on how long.
We can talk offline about it. There is a way to do that.
Yeah, exactly.
Don't believe that issue that you can't transfer into an LLC.
Yeah, exactly. All right, Garrett. Thanks so much, man. Enjoy the rest of your weekend. All right.
Take care.